three European Union schemes of geographical indications and traditional specialties, known as protected designation of origin, protected geographical indication, and traditional specialities, guaranteed, promote and protect names of quality agricultural products and foodstuffs. They are based on the legal framework provided by the EU Regulation No. 1151/2012 of the European Parliament and of the Council of 21 November 2012, on quality schemes for agricultural products and foodstuffs. This regulation ensures that only products genuinely originating in that region are allowed to be identified as such in commerce. The legislation first came into force in 1992. The purpose of the law is to protect the reputation of the regional foods, promote rural and agricultural activity, help producers obtain a premium price for their authentic products, and eliminate the unfair competition and misleading of consumers by non-genuine products, which may be of inferior quality or of different flavor. These laws protect the names of wines, cheeses, hams, sausages, seafood, olives, olive oils, beers, balsamic vinegar, and even regional breads, fruits, raw meats and vegetables. Foods such as gorgonzola, parmigiano reggiano, feta, the Waterford Glass, Herve cheese, Melton Mowbray pork pies, Piave cheese, Asiago cheese, Camembert, Herefordshire cider, cognac, Armagnac and champagne can only be labeled as such if they come from the designated region. To qualify as Roquefort, for example, cheese must be made from milk of a certain breed of sheep, and matured in the natural caves near the town of Roquefort-sur-Soulzon in the Aveyron region of France, where it is colonized by the fungus Penicillium roqueforti that grows in these caves. This system is similar to appellation systems used throughout the world, such as the appellation d'origine contrôlée used in France, the denominazione di origine controllata used in Italy, the denominação de origem controlada used in Portugal, the denomination d'origine system used in Spain, and the denumado de origine controlata system used in Romania. In many cases, the EU PDO-PGI system works parallel with the system used in the specified country, and in some cases is subordinated to the appellation system that was already instituted, particularly with wine, for example, and in France with cheese. For example, Mouai has both PDO in French and AOC classifications, but generally only the AOC classification will be shown. Protection and enforcement. In countries where protected geographical status laws are in force, only products which meet the various geographical and quality criteria may use the protected indication. It is also prohibited to combine the indication with words such as style, type, imitation, or method in connection with the protected indications, or to do anything which might imply that the product meets the specifications. Protected indications are treated as intellectual property rights by the Customs Regulation 1383/2003, and infringing goods may be seized by customs on import. Within the European Union, enforcement measures vary. Infringement may be treated as counterfeit, misleading advertising, passing off, or even as a question of public health. Outside Europe, the protection of PGS products usually require bilateral agreements between the EU and the importing countries, while protected indications may not always supersede other intellectual property rights such as trademarks. On the 15th of November 2011, the European Court of Auditors presented its report. The design and management of the geographical indications scheme allow it to be effective, to the European Parliament, Objectives of the protection. The preambles to the regulations cite consumer demand for quality foodstuffs, and identify a number of goals for the protection regimes. The promotion of products with specific characteristics, particularly those coming from less favored or rural areas. The improvement of the income of farmers, in return for a genuine effort to improve quality. The retention of population in rural areas, the provision of clear and succinct information to consumers regarding product origin. The provision of a recompense for efforts to improve quality and the need for consumer protection are often cited as justifications for trademark protection in other domains, and geographical indications operate in a similar manner to trademarks. General regime. The general regime governs the use of protected designations of origin and protected geographical indications for food and certain other agricultural products. There are separate regimes for spirits and for aromatized drinks as well as for wines. The origin of the product is only one of the criteria for use of the protected terms. The product must also meet various quality criteria. The label, traditional specialities guaranteed, is a similar protected term which does not impose any restrictions on the geographical origin of the product. The protection of geographical indications was extended to foodstuffs and other agricultural products in 1992. Given the widely different national provisions, this general regime gives much more power to the European Commission to ensure a harmonized protection across the European Union. It is currently governed by the Regulation on the Protection of Geographical Indications and Designations of Origin for Agricultural Products and Foodstuffs. To qualify for a PDO, the product must have qualities and characteristics which are essentially due to its region of production. It must also be produced, processed and prepared exclusively within the region. The requirement for a PGI is slightly less strict. A good reputation of a product from a given region is sufficient if any of the steps of production, processing and preparation may take place within the region. Otherwise, the protection afforded by the two terms is equivalent. An application for a PDO or a PGI is first made to the authorities of the relevant member state. It is judged by the member state against the criteria in the regulation and, if found to be acceptable, forwarded to the European Commission for final approval. Applications are published at both the national and community stages of examination, and third parties can object to proposed PDOs or PGIs which they feel would harm their business. A recurrent objection is that the proposed denomination is a generic term for the product in question. Generic names cannot be registered, but, once registered, the denominations are protected from genericization. Hence, cheddar cheese was deemed to be a generic name, but the PDO, West Country Farmhouse cheddar cheese, was allowed. Feta was deemed not to have become generic, and was registered as a PDO to the disappointment of cheesemakers outside of Greece. Description of the regimes. Protected designation of origin. The protected designation of origin is the name of an area, a specific place, or, in exceptional cases, the name of a country, used as a designation for an agricultural product or a foodstuff which comes from such an area, place, or country, whose quality or properties are significantly or exclusively determined by the geographical environment, including natural and human factors, whose production, processing and preparation takes place within the determined geographical area. In other words, to receive the PDO status, the entire product must be traditionally and entirely manufactured within the specific region and thus acquire unique properties. Protected geographical indication. The protected geographical indication is the name of an area, a specific place, or, in exceptional cases, the name of the country, used as a description of an agricultural product or a foodstuff which comes from such an area. area, place a country, which has a specific quality, goodwill or other characteristic property, attributable to its geographical origin. At least one of the stages of production, processing or preparation takes place in the area. Geographical indications and traditional specialities. European Commission. In other words, to receive the PGI status, the entire product must be traditionally and at least partially manufactured within the specific region and thus acquire unique properties. Traditional specialities guaranteed. The TSG quality scheme aims to provide a protection regime for traditional food products of specific character, differing from PDO and PGI. This quality scheme does not certify that the protected food product has a link to specific geographical area. To qualify for TSG, a food must be of specific character, and either its raw materials, production method or processing must be traditional. Under Art. 3 of Regulation 1151/12, specific character is defined as the characteristic production attributes which distinguish a product clearly from other, similar products of the same category. Under Art. 3 of Regulation 1151/12, traditional is defined as proven usage on the domestic market for a period that allows transmission between generations. This period is to be at least 30 years. For a food name to be registrable under the TSG scheme, it must have been traditionally used to refer to the specific product, or identify the traditional character or specific character of the product. A TSG creates an exclusive right over the registered product name. Accordingly, the registered product name can be used by only those producers who conform to the registered production method and product specifications. The legal function of the TSG is to certify that a particular agricultural product objectively possesses specific characteristics which differentiate it from all others in its category, and that its raw materials, composition and method of production have been consistent for a minimum of 30 years. Thus, TSG food denominations are registered trade signs with a distinctive function. Relationship to trademark law. In principle, a similar protection to a geographical indication could be obtained through a collective trademark. Indications which serve exclusively to identify the place of origin of goods are not registrable as trademarks under Art. 6 quinquis. B.2 of the Paris Convention for the Protection of Industrial Property, which has effect in European Union law by Art. 7 of the Regulation on the Community Trademark and by Art. 3 of the Directive to approximate the laws of the member states relating to trademarks. However, marks which also serve to identify the quality of a product originating in a certain region may be registered so long as they have not become generic in the trade concerned. Trademarks which have been registered before the registration of a PDO or a PGI may continue to be used, but the registration of an equivalent trademark after the approval of a PDO or PGI is impossible. No. 510/2006. The existence of a trademark may be a reason to refuse the registration of a PDO or a PGI. Hence the Polish geographical designation, herbal vodka from the North Podlasie lowland aromatized with an extract of bison grass, so phrased as to avoid infringing the trademark, a brauka. Special regimes. The protection of geographical indications for wines and other alcoholic drinks was historically the first to be developed at both national and community level. It is also the only protection which is recognized by the Agreement on Trade-Related Aspects of Intellectual Property Rights, administered by the World Trade Organization. Although the European Union is pushing for other geographical indications to be included in the Doha round of World Trade negotiations, Wine's European Union rules governing the production of wine are considerably longer than community trademark law. The main text, the regulation on the common organization of the market in wine, runs to over 46,000 words. To be considered as a quality wine, the wine must come from a specified region and be associated with a geographical indication or appellation. Indeed, the technical term used in the regulation is quality wine PSR, with the PSR standing for produced in a specified region. Wines which do not meet this requirement may only be marketed as table wine. Despite the traditional importance of appellations for wine, there has been little harmonization of national provisions within the European Union. Member states delimit the specified areas of production and determine the rules and appellations which apply. The European Commission restricts itself to publishing the information provided by the member states. Appellations are usually the geographical name of the area in which the wine is produced, although there are some historical exceptions. Muscadet and Blanquette in France, Cava and Manzanilla in Spain, and Vinho Verde in Portugal. The appellations are not necessarily unique. Cava may refer either to a quality sparkling wine PSR produced in Spain or to a Greek table wine which has been aged. Spirits. The regulation laying down general rules on the definition, description and presentation of spirit drinks provides for a double system of protection of spirit descriptions. Spirits are divided into 21 categories, which each have rules for fabrication and minimum strength. Within these categories, certain names are reserved for drinks from particular countries, for example ouzo, which is aniseed-flavored spirit drink which must have been produced exclusively in Greece, or Cyprus, or grappa, which is a grape-marked spirit produced in Italy, or palinka, which is a purely fruit-based spirit produced in Hungary. The regulation also defines a number of geographical designations, which are reserved for drinks which acquired the character and definitive qualities in the area denominated. The exact delimitation of the areas and any other regulations are left to the member states concerned. By way of derogation, the designations Königsberger Barenfang and Ostpreußischer Barenfang are permitted for certain German drinks even though they refer to Königsberg and East Prussia, which are no longer part of Germany. Aromatized drinks. The regulation laying down general rules on the definition, description and presentation of aromatized wines. Aromatized wine-based drinks and aromatized wine product cocktails institutes a system of protected denominations for aromatized drinks which is very similar to that for spirits. The association of general names with specific countries is weaker. A drink labeled simply sangria must have been produced in Spain or Portugal, for example, but it is permissible to label a drink sangria produced in the United Kingdom. Aromatized wine-based drink if the drink meets the other requirements to be described as sangria. Similarly, the denomination claria on its own is reserved for drinks produced in Spain. The protected geographical designations are Vermouth di Torino, Nürnberger Glühwein, Vermouth de Chambéry. Within the European Union, Article 13 of this legislation states that registered designations are protected against ... any usurpation or imitation, even if the true origin of the product is indicated or if the appellation is used in translated form or accompanied by terms such as kind, type. This legislation expanded the 1951 Stresa Convention, which was the first international agreement on cheese names. 7 countries participated: Austria, Denmark, France, Italy, Norway, Sweden, and Switzerland. Selected products include Prosciutto Toscano from Italy, Brinza Podolanska and Osipek from Poland, Marchfeldspargel from Austria, Lübecker marzipan from Germany, Scotch English beef and lamb from Scotland, Brinza and Ostipok from Slovakia, Kaszubsko Malina from Poland. In certain cases, the name of widely popular products became generic, and therefore could not be protected afterwards. Cheddar cheese, for instance, originating in the English village of Cheddar, is produced in many countries, including the US, Canada, Australia and New Zealand. Hence the cheddar name is not protected, but the more specific name, West Country Farmhouse Cheddar, is. Other products are protected in Europe but not elsewhere. Buffalo mozzarella, for instance, is protected in Europe, but the name is used without restrictions by US dairy companies. The geographical limitations can be quite strict. Newcastle Brown Ale was restricted to being brewed in the city of Newcastle upon Tyne in England. However, having obtained this protection for their product, the brewery decided in 2004 that it would move across the River Tyne to Gateshead. As Gateshead is technically a separate town, albeit only the width of a river apart, it does not fall within the required geographical restriction. The brewery then applied to the European Union authorities to have the geographical restriction revoked. If the restriction had not been revoked, the brewery would have been forced either to move back to Newcastle, or stop calling its beer Newcastle Brown Ale. Ultimately, the brewery's application to revoke the geographic restriction was approved. Similarly, Stilton cheese can only be produced in the 3 English counties of Derbyshire, Leicestershire, and Nottinghamshire. Stilton Village is in the traditional county of Huntingdonshire, now a district of Cambridgeshire, so Stilton cheese cannot be produced in Stilton. New season Coma potatoes or Coma Earlies were awarded PGI status in 2012. Only immature potatoes grown in the restricted geographical area surrounding the town of Coma in Northern Ireland, harvested between the start of May and the end of July, can be marketed as Coma Earlies. Outside the European Union, there is no unconditional protection for these names on products both made and sold outside the EU. However, there are a number of bilateral agreements with the EU for some level of enforcement. Agreements of this type exist between the EU and Australia, Canada, Chile, Colombia, Mexico, and South Africa. Australia. Following an agreement during the 1990s by the Australian Wine and Brandy Corporation and the Australian and EU governments, the others GIs and the nation's traditional terms of winemaking were meant to have been protected by 1997. However, this has been proceeding slowly, and while some GIs have been protected in Australia, others are still available for use. It seems unlikely it will have any effect on colloquial speech in the short term. Colombian coffee was protected by the PDO in August 2007. In Canada, a 2003 agreement made with the EU provides for protection of the names of wine and spirits. The new classification of names will be done in phases. By the end of 2013, all of the affected names will be protected, including Chablis, Champagne, Port and Sherry. Under the Comprehensive Economic and Trade Agreement between Canada and the EU, Canada agrees to protect 143 geographical indications for high-quality European products, such as Roquefort cheese, balsamic vinegar from Modena, Dutch Gouda cheese and many others. Georgia, Mexico. The General Declaratory for the Protection of the Papantla Vanilla and Charanda sugarcane sprit from state of Michoacán was published by the Instituto Mexicano de la Propiedad Industrial. Likewise, the official Mexican standards specify that tequila must be produced from agave of the Tequila and a Weber Blue variety, grown in a number of municipalities whose soil, weather and geographical conditions match the ones required for the plant's optimal growth. Only a liquor that fulfills all the requirements specified by the official Mexican standard can be called tequila. Failure to comply will result in legal action by the federal government. Switzerland. The appellation d'origine certifies that everything, from the raw material to the processing and the final product, comes from one clearly defined region of origin. The indication Geographical certifies that food products were either manufactured, processed or prepared at the place of origin. The appellation d'origine certifies wines. United States. In the United States there are groups that have some degree of protection for the regional designation. For example, Vidalia onions must be produced within a certain region around Vidalia, Georgia, as defined by the Georgia Department of Agriculture, and 100% Florida orange juice is certified as being such by that state's Department of Citrus. Some of these marks are protected in the United States under certification mark law, such as the Idaho Potato Commission's Idaho and Grown in Idaho registered trademarks for potatoes. Tennessee whiskey is straight bourbon whiskey produced in the state of Tennessee. This definition is legally established under the North American Free Trade Agreement, which states that Tennessee whiskey is a straight bourbon whiskey authorized to be produced only in the state of Tennessee. There are also cases in which a geographical name has been trademarked for a particular product that might not even be manufactured there, such as Philadelphia cream cheese. List of products with PDO/PGI/TSG classifications. A complete list of agricultural products with a European Union protected designation of origin, protected geographical indication, or traditional specialities guaranteed, listed alphabetically by nation, is at the European Agriculture site.